Good afternoon, everyone, and welcome to the second webinar of this series on the ICO's Direct Marketing Code. My name is Nuria Pastor, and I'm a director at the Fieldfisher's Privacy, Security and Information team in London. And today I'm joined by my colleague Camille Ebden. So before we start, a couple of housekeeping points. So everyone has been muted. And of course, if you have any questions, you can use the question box provided in the control panel, and we will go through the questions at the end of the session. We have quite a lot to go through. As you know, the ICO code is quite detailed, and we have quite a lot of content to go through. So yeah, questions at the end of the session. So what are we going to cover today? So this session focuses on how to achieve compliance with privacy regulations when you buy or sell personal data from third parties. In particular, we will cover the following topics. So first of all, by way of recap from the first session, Camille will take us through what the ICO's Direct Marketing Code is and why it's important. We will then look at what we can and cannot do when we obtain personal data from third parties or public sources for direct marketing purposes, or when we use third parties to send marketing on our behalf, and also when we share or sell personal data for direct marketing purposes. So I will now hand over to Camille for the introduction to the code.
Hi, afternoon everyone. So as Nuria says, this section will be familiar for anyone who attended our webinar last week, but just briefly to recap, the code is still in draft form and the finalized version is expected later this year. Could we just move to the next slide, please? And the code applies to anyone who processes personal data for direct marketing purposes. And direct marketing purposes are not defined in the GDPR or the Privacy and Electronic Communications Regulations, PECA, but the code says the term includes all the processing activities leading up to and supporting the sending of direct marketing. So for example, data cleansing, matching, or screening. So if we just go on to the next slide, please. The code has a notable emphasis on 21st century marketing, profiling, and enrichment practices. And the ICO sets out that where companies don't comply with the code, they'll find it difficult to demonstrate that they've complied with the GDPR and PECA. And the ICO also set out that they will carry out proactive audits of compliance with the code. So Nuria is now going to take us through the first section of this presentation.
Thank you very much, Camille. And please, if we can go to the next slide now. Our first section will focus on the scenarios where we have obtained personal data from third parties or public sources. So moving on to the next slide, please. So now, just to recap, new leads can be generated from a number of sources: third parties who sell or rent lists, or public available sources such as the company's house or websites. The ICO reminds us that just because you have not obtained the personal data directly from the individual, it does not mean that you do not need to comply with the transparency requirements under the GDPR. As you know, Article 14 of the GDPR sets out the information that you must provide to individuals whose data you do not obtain directly. It also requires that this information is provided within a month. This is sometimes tricky or indeed expensive to do, as you may not have a lot of information about the individual. So, for example, you might only have the postal address. So is there a way out of complying with the transparency requirements? Well, in theory, there is. So Article 14 sets out some exemptions to the provision of notices to individuals. So for example, you will not be required to provide a transparency notice to individuals when the provision of such information proves impossible or would involve disproportionate effort. But when can we apply these exemptions? So the ICO warns that the exemptions to the transparency rule are unlikely to apply in a direct marketing context. And we will later discuss a real life example where an organization tried to rely on the disproportionate effort exemption, and it was fined by the Polish Data Protection Authority. Even if you plan on relying on this exemption, you would still need to have a notification on your website and carry out a data protection impact assessment to assess ways of mitigating the risks of carrying out what the ICO calls invisible processing. So let's move to the due diligence activities that you will have to carry out when you use data from others. When you obtain, actually, we can stay in the previous slide, that'd be great. When you obtain personal data from a third party, contractual reassurances from the third party about the fact that the data is quote unquote GDPR compliant will not be enough. The ICO says that you will need to carry out your own proportionate due diligence checks. But what is proportionate? We will look at this in more detail in the next slide, but let's stay on this slide for the time being. So before we move on, let's take a look at the legal grounds for processing. So once a reliable and compliant database has been obtained, you must ensure you have lawful basis for processing the data. So you must also ensure that you do not contact any individual who has already objected to receiving direct marketing from you. So what you will have to do is screen the database against your own suppression list. You should also be prepared to deal with any inaccuracies or complaints which arise from the use of the data. Beware, it will be a bad sign if you receive a lot of complaints from the individuals whose personal data you have sourced from a third party, and this may indeed flag that the data was not lawfully obtained or that there are issues with the data. So you will have to go back to your due diligence checks. So is publicly available data fair game? So you're not prevented from collecting and using personal data obtained from public sources. So for example, the Open Electoral Register or the Companies House. But the GDPR and the PECR will still apply. So in terms of your obligations, the same obligations will apply that the ones that I've just discussed, with the difference that you'll not be able to carry out the same due diligence activities because you won't have a contract with that organization. So let's move on now to the next slide to look at the due diligence activities in a bit more detail. So what I've done here, I've actually copied, and as you can see, it's quite small font for a presentation, but that's because the ICO has made a lot of suggestions in terms of what is the necessary due diligence. So in the code, the ICO says that these are checks that you could carry out, as opposed to saying that you must carry them out. In any event, these are likely to be required in most instances. So I won't read them out. Obviously, you can do that in your own time, and you can find them in page 53 of the code. But they include, for example, checking the origin and age of the data, checking the notice that has been provided to individuals at the time of collection, or the method of collection, and records of consent. The ICO also recommends having a written contract in place, which includes audit rights, something that, as we know, is sometimes tricky. This is not a new concept. The concept of doing due diligence in this context is not totally new. The ICO already recommends in the previous code some checks. However, this guidance with the new code of practice is much more detailed. So only time will tell what the ICO considers proportionate due diligence checks. We don't have an understanding of this currently in the code. So I will now move on to discuss the fine that I mentioned earlier. So if we can go to the next slide, please. Thank you. So this is the so-called Bisnode fine, because that's the company that was fined. So this fine was imposed in late March 2019, and we have had a court decision in addition to the decision of the Data Protection Authority. The court decision was a few months ago, was last December. So this was the first time where a data protection regulator in the EU imposed a fine for what the Data Protection Authority understood was the wrong application of the disproportionate effort exemption under Article 14 of the GDPR. Just to recap, as we've said a few minutes ago, one of the exemptions to the transparency obligations under the GDPR can be relied upon when providing a notice would constitute a disproportionate effort for the organization. So the Polish DPA fined Bisnode approximately, that depends on the currency exchange, but about 220,000 euros for failing to comply with its information obligations under Article 14 in connection with the database involving sole trader data. Bisnode obtained data from public sources in order to provide company verification services. The company held millions of records on individuals, on sole traders. So what Bisnode did, they provided notices to some of these individuals by email in compliance with Article 14. However, there were about 6 million individuals for whom they did not have email addresses. So they either had postal addresses or telephone numbers. So in this context, the company decided not to fulfill the information requirement under Article 14 towards these data subjects on the basis that doing so would constitute a disproportionate effort, particularly as they calculated that it would cost approximately 8 million euros to send this information to each person by traditional post. So as you can see, Bisnode did, however, provide this information on the website as it is required under Article 14. So as you can see, they did take some steps to comply with transparency obligations. So the Polish Data Protection Authority fined Bisnode because they believe that sending the information by post or on the telephone was not an impossible activity, and it did not require a disproportionately large effort. However, the DPA did confirm that conducting additional searches to find the required contact details would be, in fact, a disproportionate effort. So what happened after the fine? So Bisnode appealed, and the court decision was issued, as I said, in December last year. The court upheld the decision that Bisnode could have only relied on the disproportionate effort exemption if contacting the data subjects was impossible or virtually impossible. Organizational or financial costs would not outweigh the right to have one's data protected. That's what the court said. So, however, the fine imposed has been suspended, and the court has sent the matter back to the Data Protection Authority to go through the administrative proceedings again and recalculate the fine. So, what are the main takeaways from this case? So the first one is that the interpretation of the disproportionate effort exemption is very narrow, and it will only apply when contacting the data subjects is impossible or virtually impossible. And organizations do not need to look for more information than the information they already have in order to comply with Article 14. So of course, this is only a decision and it's not by the UK regulator, so why should we care? Well, under the GDPR, EU data protection authorities have the ability to cooperate with each other and will sometimes liaise with each other when making decisions. So it is important to keep an eye on what happens in other jurisdictions. So we'll now move on to consider the so-called tell a friend schemes. So next slide, please. So businesses sometimes ask their own leads to share contact details of their friends and family with them for marketing purposes. I would say this is a relatively common practice thing to do. The ICO acknowledges that it is very difficult to demonstrate compliance in this context, and it goes further to say that collating personal data in this way will put businesses in a position where they will be likely to breach PECR because consent will not be valid. Other models might be applied, for instance, when the customer sends the communications directly to their contacts, but these schemes will also present challenges. So actively encouraging individuals to forward your direct marketing messages to their friends still means that you're instigating the sending of the message. So you must comply with PECR, and it would be tricky to do so given the high consent standards under the GDPR. So I'll now move on to discuss data enriching and profiling. Next slide, please. So profiling and data enriching activities will help you know your clients better, so they have clear commercial benefits. So what are the compliance challenges? So, well, first we'll consider profiling activities. So to recap, profiling is where the behavioral characteristics of individuals are analyzed to find out about their preferences, to predict their behaviors, to make decisions about them or classify them into different groups or sectors. So profiling activities may be based on assumptions or predictions of the individual's behavior. So for example, analyzing loyalty card data will help you decide what products the customer might be interested in. Profiling activities might have consequences. For example, the restriction of the choices of individuals or the perpetuation of stereotypes. And importantly, that's something the ICO highlights, individuals might not be aware or they might not understand these consequences. So transparency is therefore paramount in this context. You'll need to ensure you have told individuals about the fact that you're using third-party information in order to add extra data about them for profiling purposes. So let's look now at the legal grounds for processing. So you'll be able to ensure, so you'll have to ensure that valid legal grounds for processing are in place before carrying out any profiling activities. So is consent always required? Well, the ICO suggests that it might be possible to rely on legitimate interest. However, it makes clear that this is unlikely that you will be able to apply legitimate interest for intrusive profiling for direct marketing purposes. Profiling activities may be subject to restrictions of automated decisions making of Article 22 of the GDPR. This will happen when the decisions you make have certain effects. So these are legal effects or similarly significant effects. It's a bit of a tongue twister on the individuals, and if there is no human involvement in the decision process. So if that's the case, you will need the individual's explicit consent to carry out those profiling activities. So for example, targeting individuals known to be vulnerable because they are gamblers with adverts for betting websites will have similarly significant effects on these individuals, and they would therefore be caught, these activities would be caught by Article 22 of the GDPR. You will also need the individual's explicit consent if you profile individuals based on their special category data. And finally, on profiling, it's important to bear in mind that large-scale profiling is likely to consider to require a DPIA. And this is based not only on the ICO guidance, but also on the EDPB guidance. So in terms of data enrichment is where you use other sources, so for example, data from data brokers, to find out more information about individuals to add to your existing profile or your existing information about them. So for example, you could find out about their interest or buying habits or postcode data. It is unlikely that individuals can anticipate that you will enrich their data in order to get to know more about them. When enriching a personal data set with information obtained for a third party, you must check that the third party has told the individuals about the fact that they will share or sell the data to you. You will need to carry out the due diligence activities that I explained earlier in the presentation. So we can move on now to the next slide. So in the next couple of slides, I will explain similar ways in which you can enhance your databases using information sourced from third parties, and what does the ICO advises in relation to this. So first of all, we'll look at data matching. This involves matching the personal data of an individual you already hold in order to add contact details that you did not have, for example, by buying additional contact details. The ICO sets out that buying such additional contact details is likely to be unfair unless the individual has expressly consented to it. The ICO goes on to say that this is likely to be true no matter how clearly you explain this in your privacy policy, that you might seek out further personal data from third parties, as it removes from individuals the choice of the channels that they wish businesses to communicate with them. So you cannot assume that an individual forgot to give you certain personal data, for example, another email address to the one that you hold, and that the individual is happy for you to contact them by other channels. It must be for the individual to choose what details they give to you. So the consent required might be obtained by you or a third party. If obtained by a third party, you must be satisfied that the consent is valid, as we explained earlier. So next we'll go through what the ICO thinks about data cleansing and tracing services. So next slide, please. Great. So data cleansing is the process of removing contact details of those who are, for example, deceased or the details are out of date in your database. Tracing is the process of updating the contact details, so for example, addresses of individuals. So removing out the contact details of deceased will help you comply with the accuracy and data minimization requirements. So that should not be an issue. However, the use of tracing services for direct marketing purposes is unlikely to be compliant unless there is clear evidence that the individual is happy to have their new contact details shared with you. So for example, if they have ticked the box in order to choose this. So if there is no evidence of a recent expectation that the updated contact details should be shared, it is highly likely that the tracing would be unfair or unlawful. Consent to receiving direct marketing to the old address cannot be transferred to the new address, even if you suspect that the individual has simply forgotten to give you the new contact details. So you will not be able to rely on your legitimate interest in order to carry out tracing activities, because your commercial interest in continuing to market the individual are likely to outweigh the rights of the individual to not tell you about the new contact details. So here it's clear that there is a tension between respecting individuals' rights to control their personal data you process and your obligation to keep the personal data up to date. However, the ICO says that the steps to keep your data updated must be proportionate and reasonable, and that it will be difficult to take intrusive steps, such as tracing, to keep contact details for direct marketing up to date. So that's it for me. So we'll now move on to Camille, who is going to take us through sections 2 and 3 of the presentation. So Camille, the floor is yours.
Thanks very much, Nuria. So if we could go on to the next slide, and one more, please. So we're going to look at now the issue of using third parties to send direct marketing communications. So this is quite a common practice, and it can take different forms, such as where you provide a third party with the contact details of your customers, and you ask the third party to send your customers direct marketing on your behalf. Or another example would be where you ask a third party to use their own marketing lists to send your direct marketing content to individuals. And that's also known as hosted marketing. You're not prohibited from using third parties to send direct marketing communications, but you do have to ensure that you comply with the direct marketing rules, even though you're not physically sending the marketing yourself. So do you still need to comply with PECA in particular? Well, PECA applies to the sender, caller, or instigator of direct marketing messages. Instigator is not a term that's defined in PECA, but the ICO's code sets out that where you ask, encourage, or incite a third party to send your direct marketing communications, you will count as the instigator. And therefore, you'll still be subject to the direct marketing rules under PECA. And you might think that the third party will always be a processor, but it depends. So from a GDPR perspective, you could even be joint controllers with the third party if the direct marketing is a joint initiative and you are jointly determining the purposes and means of the direct marketing. If the third party is purely sending the direct marketing on your behalf, then there is very likely to be a controller-processor relationship. The key thing is you'll need to carefully consider which roles apply, as the roles of the parties will have an impact on their obligations under GDPR and will also determine whether you need controller-to-controller terms or controller-to-processor terms in place. Also, if you and the third party are joint controllers, don't forget that you will also need to comply with the requirements of Article 26 GDPR. So if we have a closer look at joint initiatives, if you're carrying out a joint initiative with a third party, make sure that the consents relied upon are appropriate for the initiative. The code gives an example of a supermarket who are planning to send out to its customers a promotional email about a charity that the supermarket is supporting. Now, although the supermarket is not passing the contact details of its own customers to the charity, the supermarket still needs to ensure that there is appropriate consent from its own customers to receive direct marketing that promotes the charity. The code also sets out that where possible, it would be good practice for the supermarket to screen against the charity's suppression list. Now, just a brief mention of Tell a Friend. As Nuria mentioned earlier, one type of Tell a Friend scheme is where you actively encourage individuals to forward your direct marketing messages to their friends. And as she mentioned, you would still be classed as an instigator where you operate such schemes, and therefore you would still need to comply with PECA. And the code sets out that sending direct marketing emails and texts via a Tell a Friend scheme would most likely breach PECA, as you would not have consent from the ultimate recipients. So do tread carefully if you are considering that type of scheme. So we'll now move on to the next section. So if we could go on to the next slide, please, and then the next one. And we're going to look at the issue of sharing or selling data for direct marketing purposes. So the whole business model of data brokers is, of course, to collect data about individuals, often from a variety of sources, combine it and sell it on to other organizations. And data broking services can include selling lists of contact details, enrichment, profiling, data matching, and data cleansing, just to name a few. However, personal data is also commonly shared in other contexts for direct marketing purposes, such as with a business partner. So can you share personal data or sell it for direct marketing purposes in a compliant way? Well, yes, but do ensure that you comply with the GDPR and PECA where applicable. And do bear in mind that just because you don't get paid for sharing personal data, you're not absolved from complying. So to take us through some of the requirements, we're going to first look at the issue of transparency. So of course, if you obtain the data directly from individuals in order to share or sell it for marketing purposes, then you must be transparent with those individuals and provide them with all the relevant information about your purposes and all the relevant Article 13 GDPR privacy information. But also don't forget that if you obtain data about individuals via third parties, you're still subject to transparency obligations under Article 14 GDPR. You must be transparent and inform the data subjects how you plan to use the data and also the source of the data, as Nuria mentioned earlier. So if we look now at the issue of lawful basis, you'll need to consider both the GDPR and PECA when considering your lawful basis for sharing or selling personal data for direct marketing purposes. And firstly, if we think about consent, if you're seeking to rely on an individual's consent, you must ensure that any such consent is valid to sell or share the individual's data for direct marketing purposes. Make sure, as ever with consent, that it's specific, it's unambiguous, it's informed, it's freely given, and also make sure you have clear records of it. The code also highlights that you cannot infer consent just because you're selling a list to an organisation with similar objectives as you. For example, a charity cannot simply sell its marketing list to another charity with similar aims on the assumption that its contacts won't mind receiving direct marketing from the similar charity. So if we turn to look at legitimate interests, the code states that you cannot always use legitimate interests to sell data for direct marketing purposes. It goes on to give an example that you can't rely on legitimate interests to sell unconsented data for email marketing. This does leave the door open for there being some circumstances where potentially you could rely on legitimate interests to sell data for direct marketing purposes, albeit the code doesn't give any specific examples. Remember, though, that to rely on legitimate interests, you must be able to justify your disclosure to the third party. You must be able to take into account the reasonable expectations of the individuals by carrying out a three-part legitimate interest assessment. And the assessment should consider, for example, the nature of the relationship with the individual, whether the data was collected directly from the individual, when it was collected, what individuals were told about how their data would be shared and used, and how the legitimate interests pursued balance against the rights and freedoms of the data subjects. And the code also states that as a safeguard, when you first collect details from individuals, you should include a clear and simple opt-out opportunity that individuals can use if they object to you sharing or selling their details to third parties. And remember, individuals have an absolute right to object at any time to the processing of their data for direct marketing purposes. Now, for data brokers, they should be aware that an Article 29 Working Party opinion suggests that consent would be required for data brokering. The draft code also points out that it's unlikely to be in people's reasonable expectations that data brokers will build extensive profiles on them in order to sell such profiles to lots of organizations. So what about switching lawful bases? The code sets out that where data was collected on the basis of consent, you cannot then switch to relying on legitimate interests as the legal basis for further processing activities for direct marketing purposes. If you did so, the switch would mean that the original consent was no longer specific or informed, and it would actually have misrepresented the degree of control in the hands of the individual. Due diligence. So just as we explained in section 1, if you haven't collected the data directly from the individuals, you must carry out due diligence checks to ensure that the data has been lawfully obtained and that there is a legal basis for processing it for direct marketing purposes. Always remember accountability. You have to be able to demonstrate that your marketing list and practices comply with the GDPR and PECA. So it's really important to maintain records of how and when you collected the personal data and what individuals were told at the time of collection. And lastly, don't forget the obligations regarding communicating certain types of data subjects requests. If you receive erasure or rectification requests from data subjects, you're required to pass these down the chain to the third parties to whom you've sold or shared their personal data, unless this proves impossible or requires a disproportionate effort. So that's the end of the 3 sections we're presenting today. If we could just go to the next slide, please. We're just going to run through as a quick reminder the different perspectives we've looked at in terms of direct marketing activities involving third parties. So we've looked at using data obtained from third parties, using third parties to send your marketing communications, and sharing or selling data for direct marketing purposes. So I'll hand back to Nuria now.
Thank you very much, Camille. And thank you everyone for bearing with us. I can see you're still all online. So now it's time to for some questions. So I can see that we have 10 minutes left. If anybody has any questions, please use the control panel to ask these questions. And whilst we wait for these to arrive, I can't see any questions at the moment. I would like to also explain that obviously data protection is a very active field, and we are certainly not bored. So this week is an important week for data protection, because in addition to obviously our seminar, there is something else coming up, which is the decisions for the Schrems 2 case. So maybe if we can move to the next slide. Sorry, yeah, if we could move to the next slide. So just to say that in the next few days, so on Friday and next Monday, our team is hosting a couple of sessions on the Schrems 2 decision, which is going to be announced on Thursday. So I am told that there are questions. Apologies for not having seen this. So I think, okay, hang on a minute. Let me just see. I'm having some formatting issues to read the question. So Camille, why don't you read out the question? Oh yeah, I can
Sure,
see a number of questions. Apologies.
sure, no
So
problem.
yeah, yeah, go for it.
Okay, so I can see a question here. Can you ever ask a contact to opt back into direct marketing?
So that would be a contact that has opted out, I assume. And this is a question from Shannon. Thank you, Shannon. This is very tricky, I would say, in practice. We have seen regulatory activity in these sorts of situations. So obviously, I would be more than happy to discuss the specifics with you, Shannon. But I think in practice, if someone has opted out, unless they provide you with the details, say that they become a customer again and they provide an explicit opt-in, I wouldn't go back to them and ask them to, whether they have changed their mind and they would like to opt in again. So moving on. So I can see. Yeah, no, I can read them now. Actually, sorry, I've overcome my issues. So I can see a question about electoral roll companies that house data. Even though the data is in the public domain, the purpose is not for marketing use. Therefore, it's not a secondary use. So yes, I mean, the issues we've highlighted are issues relating to marketing activities, basically for third parties that collate this information online, for example, and then use them for marketing purposes. So it goes beyond the use that you're referring to. Then we have another question relating to data tracing activities. So the question is, how do data tracing rules apply, if at all, to business contacts when they move jobs and thus have a new email? So I think this is it's a very good question. And this actually has to do with, I think what the ICO has highlighted in the code is that it has to be clear that the individual wants you to have this additional information, as opposed to your organization going out and updating that information and noticing, because this is information that is publicly available, that actually this individual is no longer at X, Y, and Z, but is now working at another organization. So that would be the data tracing rules that the ICO has an issue with, and data tracing activities that the ICO has an issue with, because unless you are clear that the individual wants to give you the additional information or has made an attempt to provide you with that information, it'd be quite tricky to seek that information yourself. And as I said earlier in the presentation, there is a clear tension between any organization's obligation to keep their information up to date and the respect to the individual's right to control the data that you process about them. So again, that would probably not be a no-go thing to do in terms of data tracing for new jobs. Okay, so moving on to the new question. That there is a very good question here. How long does consent for marketing remain valid for? That's a very interesting question, and I think there isn't a right or wrong question answer to this question. And by the way, Camille, chip in if you want at any time. I'm just going through the questions myself, but I think that you need to look at the context, and you need to look at the activities that you're carrying out, and things, for example, like, is this individual, let's put as an example that this individual is a member of your organization, or has some sort of relationship with you. Are they active in relation to the activities that you carry out, or do they still expect that you would be sending them marketing communications? So for example, if there's someone whom you haven't contacted for a while, I'd be careful to assume that the consent is still valid, because obviously it's all about, in addition to obtaining valid consent, it's about the individual's expectations. And I think we have all received sometimes marketing from organizations and thought, oh my goodness, I didn't remember even I had given them my details. So it's being careful about this, and of course having a policy in place in relation to data retention and how long you should use the data for.
Just to add on this one, Nuria, I think also that the code also mentions that when sending direct marketing to new customers on the basis of consent collected by a third party, I think their recommendation is that you don't rely on consent that was given more than 6 months ago. So that's consent, that's where you've got data gathered from a third party, or consent gathered by a third party.
Correct. Yeah. Of course, that's true. Thank you. I have another comment here, a question, interesting as well, I think, for the whole audience, regarding the timescales where the code might be approved. And so the comment says, I heard a rumor that the final version will be delayed into 2021. Have you heard anything about this? So thank you for sharing this. I haven't heard this, but I wouldn't be surprised. I mean, as we said, the expectation of what we had heard is that it would be approved by this autumn, so in the next few months. But obviously we are in unprecedented times, and regulators are busy with other matters, and it could well be that it is further delayed into 2021. Let's hope it's not, because it's always nice to have a confirmation of the content of a draft code. I mean, normally my experience, they don't change massively once they approve the final version, but it's indeed important to have a look at the final version. So I'll be very happy if any attendees can share additional rumors that they've heard in the future. We will do the same ourselves. So yes, thank you for that. So I can see there are a few questions that we haven't had time to address, and it's now 4:30. So I will close this session, and we will address these questions directly with each of you that have posted them. Thank you very much for doing that. So I think all that there is left to say is thank you very much for attending. We really appreciate having spent some time with you discussing the ICO Draft Direct Marketing Code. I hope you've enjoyed as much as we have had. It's quite a dense topic, so I hope we haven't given you a headache and that you found it interesting. So any feedback or any additional questions you would like to send to us, feel free to do so. So until the next time, good afternoon. Thank you very much.